Yeah.
And how the rates have been fixed? Who has fixed those rates? You pay whatever you feel like. Huh?
But similarly, like in the earlier case, Lordship, like in the earlier case, it has been by internal note sheets by the district election officer.
Mm.
In the Lordship may turn to page 13 and Annexure 1. That's the order we have been given. And on page 14 down below, this has the approval of DEO Buxa at note sheet page number so and so dated 10/3/2019. So again, it's the internal. I presume that rates had been fixed by the meeting. So all the orders, similar lines are there in the bottom. And Lordship may turn to page 27, Annexure 3, where the outstanding amount is shown and the request has been sent to Chief Election Officer, Assam.
Hey, you pay interest. Election officer. Heard Mr. Dr. A. the learned counsel appearing on behalf of the petitioner. Union. The B. Chakraborty appears for the respond number 1. Mr.
M. Kalika. On
Appears
behalf of
for
P. Boru.
respond number 2 and
And
4. Mr. M. Setia appears for the respondent number 3, 5, and 6. The present petition has been filed by the petitioner, being aggrieved at the inaction on the part of the respondent authorities in not making payment of an amount of rupees 9,17,290 for the supplies made by the petitioner of plastic scale, trunk, rubber stamp, etc., as well as iCards to the tune of rupees 9,17,290. It is the case of the petitioner that, in spite of that, pursuant to work orders being issued by the district election officer, Baksa Musalpur, for the Lok Sabha elections 2019, and the supply being affected by the petitioner in the year 2019, the respondent authorities, for reasons best known, have not made any payment to the petitioner, though the said amount have been duly admitted, as would be seen from Annexure Roman 3 to the writ petition. This board takes note of that pursuant to notice being issued, an affidavit in opposition has been filed on behalf of the respondent number 2, 2, and 4, wherein at paragraph number 5 and 7, 5 and 8, the said amount have been duly admitted. The reasons assigned in the said affidavit is that the said amount would not be paid on account of funds being not made available to the district election officer, Baksa. Mr. Dr. A. Todi, the learned counsel appearing on behalf of the petition, submitted that the said amount was payable to the petitioner as within immediately upon supply being affected in the year 2019. The Learned Counsel further submitted that this cannot be a reason for delaying the payment on the ground that the funds were not available. And as such, the petitioner is entitled to interest at a rate of 18% per annum. This court have duly taken note of that in spite of the due admission, duly have heard the Learned Counsels appearing on behalf of the parties and have also duly taken note of that the respondent authorities have duly admitted that the amounts are payable to the petitioner. And for the last 6 years, the said amount have not been paid. In the opinion, therefore, in the opinion of this court, the petitioner is therefore not only entitled to the amount, but also to the interest. Taking into account the above, this court therefore disposes of the instant writ petition with the following observations and directions. The respondents herein are jointly and severely directed.
Union of India is like.
Absolutely, union also.
No.
Absolutely, everybody.
Union of India is like.
No, everybody is.
The district election officer.
I'm not concerned. Isn't it the duty of the union also as regards the elections? Are you saying that the union has no role as regards the elections? We are not concerned with the panchayat elections. We are not even concerned with the legislative assembly elections.
Is the autonomous body, they have to release the fund.
No, they have not
They have to
released
keep
the
the fund and they have to disburse it accordingly.
this court. Therefore, observes and the respondents herein are jointly and severely responsible for the payment of the amount of rupees 9 lakhs. $17,290 to the petitioner, along with interest. Next, number 2. The amount of rupees 9,17,290 be paid to the petitioner within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number 4. The amounts shall include not only the amount shall this court, having taken into account that there has been a delay in payment of the amount of rupees 9,17,290 for reasons other than good reasons have been assigned, is of the opinion that the petitioner is entitled to interest at the rate of 9% on the said amount with effect from December 14th, 2022, whereby there is a clear-cut admission on the part of the district election officer about that the amount of rupees 9,17,290 is payable to the petitioner. The said amount be paid within a period of 3 months from the date a certified copy to liquidate. Within 3 months from the date a certified copy is served upon the respondent number 4
May it please your lordship, I'm for respond number 4. Actually, the
Yes.
link was not working.
You have
so
to
I
pay.
couldn't. Yes, your lordship, I understand. Lordship, the issue is that we could not pay because the funds were not received by from the government.
I'm not concerned with that.
Lordship
Funds-
can give us 6
First
months.
of all,
6 months
no,
further.
madam, you have to understand. If the election commission does not have the money to hold the election, don't hold the elections. Don't ask for these rulers and all. If you don't have the money, you cut your cloth according to the size at which you can do it. You cannot do
Lordship-
it, whatever, just keep on ordering everything and you don't have the money for that.
Lordship,
Few
lordship will
months
give us
for
6
certified
months.
copies,
6 months,
yeah.
lordship. 6 months. If 6 months can be given, your lordship.
Supposed.
Much older.
Item 2 to 6.
Yes, what are these?
Lordship, the industrial subsidy matter, insurance subsidy for the fire insurance taken in the industries,
Affidavit is not filed.
not by Lordship.
Okay,
Come
no problem.
After notice, it's a first date, Lord.
Notice has been issued. Affidavits have not been filed, so okay. Yeah, go on the ground of non-perverse and allow your.
Lordship, they have responding number 5. Lordship. I just prayed for 2 weeks' time for filing my affidavit. I've received the Paraguay's comments. Lordship.
Then why haven't you filed it?
Lordship, just 2 weeks' time, Lordship.
Why the matter has been listed today? There was a direction passed by this court.
Lordship, the order was for returnable 5 weeks. I've made a mention or listing.
Hmm?
Notice was issued in June 2005, Lordship.
Why the matter
2025.
has come up today?
I made a mention, Lordship.
Why? And that too on Tuesday?
Permission was granted for Tuesday, Lordship.
Who is to pay the money?
It has to be released by the Industries Department, Lordship.
Hey, industry department is not, it is the central government and the central government doesn't want to file it. Who is paying for the central government? Hello? Mr.
G. Das, Lordship.
So-and-so appearing on behalf of Netfi, 2 weeks time for filing the affidavit. Industry department,
Yes,
you are not filing affidavit?
yeah, first time appearing in this case.
Are you filing your affidavit or not? My only question is that Mr. G. Bukel, appearing on behalf of the Industries Department of the Government of Assam, submits that he also requires 2 weeks time for filing the affidavit. None has appeared on behalf of the Union of India when the matter has been called. And the name and the has been called. Considering the above, list this matter again on 24th of November 2025. In the meantime, a final opportunity is being granted to the NETP, to the state of Assam, as well as the respondent number 5 to file their affidavits. As none has appeared on behalf of the Union of India, and the claim made by the petitioner herein in all the petitions pertains to claims under the Central Comprehensive Insurance Scheme 1997, which is a scheme announced by the Union of India. This court directs the registry to send a copy of this order to the Secretary to the Government of India, Ministry of Commerce and Industries, so that they may appoint appropriate counsels to protect the interest of Union of India. Huh?
Can it be after 3 weeks?
I've given it after 3 weeks on 24th of November.
No.
Good, no.
Affidavit for 2 weeks.
Item 7,
Much obliged.
Lordship,
Yes, Mr. Bhuya.
Lordship, my current friend short time for filing affidavit on 2 occasions, but till today failed to file affidavit.
Lordship, the officer is coming down for better to enter affidavit and we are finding it today.
And Lordship, another matter also pending regarding same situation, my lord, against the respondent number 3. That is, my lord, 5392. It is fixed on 2710. That may be analogous with this matter. Same respondent, my lord. Because this respondent number 3 committed this mistake again and again.
Yes. This is again the same thing.
Same respondent. 3.
Lordship, the officer is coming down.
What is wrong with your PWD? With this site, you are taking advantage of clause 7. You are segregating those persons whom you don't like and don't allow. This is the second case filed. This is the second case filed by Mr. K. Bhuya.
Lordship, here the
Another case he wanted to withdraw. I didn't allow
Yes,
him.
that is my lord 5392.
Where is that? When have I fixed
On,
that?
on,
matter?
on 27 of this month.
20?
27 of this month.
Okay. We have this on 27. File your affidavit by that.
yes.
And this is the case where we can impose constitutional courts, impose compensation to the tune they would have lost. Because this is a thing which has to be paid by these particular officers. This has to be strict. The affidavit, which was required to be filed by the respondent number 3, have not yet been filed in spite of various opportunities being granted since the month of August 2025. Mr. B. Chaudhary, appearing on behalf of the PWD department, submits that the affidavit would be filed today without fail, taking into account that a similar matter has been is already fixed on 27th of October 2025. That is WPC number
5392.
5392 of the 2025. List the present petition along with the same on 27th of October 2025.
Highly obliged.
for hearing item 8.
May it please your lordship, my lord. My lord, here in this case, earlier also we take the sea service. My lord, the respondent has not appeared in this case, my lord. Here, the railway has challenged, my lord. The award passed by the industrial tribunal dated 31/12/2014, page 12.
Where? 8.
Page 12 of the writ petition, my lord. This is on the basis of a reference by the Central Labor Department, my lord. The reference, my lord, reframe again, page 13, 4th paragraph, my lord. Whether the action of the management of NF Railway is not giving restructuring benefit to Sri Hari Komal Day and 16 others with effect from 1/11/2003, right? Order number so and so is legal and justified. My lord, this is the question posed. Before, my lord, lordship go to the, my lord, the award, the railway, my lord, in page 33, issued a policy for restructuring of Group C and Group D post, my lord.
What?
For restructuring of certain Group C and Group D cadre post, my lord.
What are these?
Yes. Now, this is of dated, my lord, 9/10/2003. That was issued by the Ministry of Railway, my lord. Para 1, this is very important, my lord. Let me read, my lord. The Ministry of Railway have had under review cadre certain C, Group C and Group D staff in consultation with the staff side with a view to strengthening and rationalizing the staffing pattern of railways. As a result of the review undertaken on the basis of functional, operational, and administrative requirements, it has been decided that approval of the president at the Group C and D categories of staff as indicated in the annexure to this later should be restructured in accordance with the revised percentage indicated therein. Well, a certain percentage was given, so far the grades are concerned. So that percentage I will show, while implementing these orders, the following details instructions should be strictly and carefully adhered. Number 1, this restructuring of cadre will be with reference to the sanctioned cadre strength on the basis of cadre strength, as on the date of following the date on which the cadre in the headquarter office of new zonal railway new divisions are closed. The benefits of restructuring will be restricted to the person who are working in a particular cadre as on the cutoff date. My lord, cutoff date has been fixed by exhibit B that I'll place that exhibit, my lord. Cutoff date is 1/11/2003. Now, my lord, lordship may kindly see page 35, para
Page
10.
42. Cut-off date is what?
Yes. My lord, this is the
restructuring
percentage.
together with-
Revised
with
percentage, my
reference
lord,
to
is
sanctions
8, 41, 26, and 25.
But what is this restructuring?
Cutoff date.
Now, what is this restructuring?
Yes.
Let us read the
Restructuring is,
order.
my lord. My lord, these are the percentage they given.
Huh?
Annexure C
Hmm.
in senior gate that these are the artisan cadres, the plater, fitter mechanic, motor trolley driver, and truck driver. These percentages are, my lord, on the existing cadres rank 8%. Earlier it was 5%, then it was enhanced to 8%. And then calculation has to be made. On that basis, the claim of the railway is that no push was created, increased by restructuring as per the policy, my lord, no push was increased. So therefore, we could not, my lord, give the benefit of these persons, 17 numbers of persons, and they allege that they were wrongly not given the benefit of restructuring before the, my lord, labor court. May I read the, my lord, evidence, my lord, that the page 17, my lord, of the workman side.
Now, what benefit does one get?
My lord,
You
if,
do one thing, I don't have too many matters today. Read the judgment.
yes, that will be, my lord.
Award.
Yes,
13.
my lord. Reference lordship has just found, my lord.
Finally come to paragraph 3.
Paragraph 3, yes. The case of the Railway Mazdoor Union, in brief, in that the workmen Sri Hari Kamal De and 16 others were employed in artisan cadre in the establishment deputy chief engineer, Bridge Line Maligaon, Northeast Frontier Railway, under the control of engineering department headed by principal chief engineer. Malo, just for a moment, I pause here, Malo. Although there were 70 numbers, now while passing the award, Malo, there were only 6 numbers of workmen. Here we are concerned with only 6 numbers that has been written here, Malo, in the award. So out of 17, 11 number they abandoned their claim. Malo.
Let us read what.
Yes, my sorry. The workers occupied different trades in separate trades, all classified as artisan cadre, both for the general purpose of personnel management and restructuring of cadre that went on the Indian Railway. The government of India, Ministry of Railway, issued a letter being number so and so, dated 9/10/2003, regarding restructuring of certain Group C and D cadre with a view to restructuring and rationalizing the staff pattern in Indian Railway. In implementing the policy regarding restructuring of certain Group C and D cadre under the aforesaid letter 9/10/2003, the establishment of Deputy Chief Engineer Bridge Line, Maligaon, left out the workmen from giving their dues benefit of restructuring of cadre. On being agreed by, they represented through Railway Mazdoor Union, NF Railway, raised industrial dispute before the Railway Administration for appropriate relief. And as the issue was not settled amicably with the union approached the Railway Labour Commissioner, Guwahati, for conciliation. But the conciliation had failed, and hence the matter came before the tribunal. The union pleaded that Railway Board initiated the policy of restructuring of cadre by the aforementioned Circular 9/10/2003, as mentioned above, with a view reducing the number of staff in Indian Railway by abolishing posts within the book of sanction for the respective cadre category grades, taking into consideration promotion of existing staff in the prescribed number of posts in a higher grade, so that some posts are abolished at the lower or other appropriate grade to finance increase in their higher or both appropriate grades post, and thus reducing total staff strength. The Railway Board subsequently issued another letter number 36/2004 in partial modification of earlier letter 9/10/2003. Thereafter, the concept was further subject to elicit and further minor modification of the certain points through various circular. Such circular number so and so dated 24/8/2004 issued by the Railway Board in answer to provide such clarification in item number 1, 2, and 3 of the Railway Board letter 17/6/2004, sought for some railways and staff side. The said circular 24/8/2004 stipulates that modification instruction provided there is classified number 2 and 3 to clear points doubt raised in regarding the earlier instruction number so and so. And circular number 17/6/2004 are to be followed. In the circular 9/10/2003, the statement of restructuring of Group C and common to all the engineering department, including workshop, was there. Therein, there is a provision restructuring of artisan staff as follows. Category artisan staff, this is the PML, existing percentage, revised percentage. This is the revised percentage we calculate, Malo.
So there were 100.
Yes.
The artisan staff.
Hmm.
There were existing 100%.
Yes,
5, 35.
Yes.
These are different grades.
right.
Now what we have done is 5 existing, which was made, has been made 8.
Yes,
And from down below,
yes,
30 has been made 25.
right, man.
30, 26.
Yes,
35 has been increased to 6
41.
by 6. So
Yes.
thereby, what you have done is that you have increased the number of posts in the higher grade,
Higher,
grade,
Right,
and thereby lower grades which were there
reduce.
were reduced.
And
Now,
they
what is
will,
the case out here of these persons?
of these persons, my lord, our case is that, my
They
lord,
were
so
artisan staff.
artisan staff, my
They
lord,
were working in which grade?
grade 3, grade 2,
What grade 3, grade 2? There is no grade 3, grade 2.
yes, my lord, that
There
is
is
there.
grade C and grade D.
Yes,
Group C and group D.
my lord, pay scale, my lord, can be, my lord, therefore, my lord, these various artisan staff consist of plater, my lord, page 42, my lord, plater, fitter mechanic, motor trolley driver and track driver. So their percentage are also, my lord, increase up to 4, 41, 26, 25. So total 100. So, my lord, while calculating
No,
with
no,
the
here
existing
if we-
cadre
if
strength,
we- No, no, these people are like this. Everybody, these are 4 grades.
yes,
So of these 4 grades, what they have reduced, if we come to page 42,
my lord,
is that some post of senior tech has been increased.
correct, my
Tech
lord.
1 has been increased.
Yes,
Tech 2 and Tech 3 has been reduced.
right.
Okay, now what is the benefit these people are asking for?
My lord, they are saying that while doing the excess, carrying out the excessive restructuring, we were left out.
Means, how will they be left out?
They say that, but so far railway is concerned, railway says their evidence also they place. No, we have done on the basis of existing cadre strength wise, and then we could not found that numbers have been increased. No post created. No post created while calculating with the existing
Let us see
cadre
the
strength.
reasons which have been given here.
Yes.
But similarly, and they were expecting benefits of the restructuring of the debt.
My lord, let me
which is
read, my
above
lord. Yes.
the important. Means
On-
what will happen is there will be more promotional avenues.
Correct, my lord. On the basis of seniority, working,
There will be more promotional avenues.
Right.
Taking into account there will be more, there
Post.
are more posts in the higher category.
higher. That's. But on the basis of above circular, in accordance with the interested seniority of the numbers of artisan cadre, including themselves as per the revised percentage cadre in the establishment deputy
What you are
superintendent.
reading,
My lord, page 15, my lord.
all the workmen were
Yes.
similarly situated and they were expecting benefits of
Restructuring cadre on the basis of the above circulars in accordance with the interested seniority of the incumbents in the artisan cadre, including themselves as per revised percentage of cadre in the establishment of deputy superintendent vigilant. But the management refused to restructure the artisan cadre in accordance with the increase in percentage as indicated above and left out this cadre while implementing the policy in respect of other categories. Thereby, the management has failed to follow the clarification number 2, circular numbers 24/8/2004 in implementing the circular.
So
Nine-
in respect to, that is the claim, that in
Their
respect
claim.
to artisan cadre,
Yes.
you have not implemented the structure.
Their claim so far the beach line is concerned, deputy chief engineer office is concerned. But we are not giving the benefit office wise. We are giving the benefit as a whole to the artisan cadre of the NF Railway. They say while giving the benefit to our similarly situated person in other division, other section, you have left out our section. This is, my lord, the purpose of implementing this policy is not like that. Section wise or the office wise, we cannot. So this is, my lord, the wrong. My lord, next line, my lord, it is
Let
pleaded.
us see the reasoning.
Uh, uh, Written statement we filed, my lord, para 4, my lord, page 16. May I read this, my lord?
The dispute was, kindly come to page 23. The dispute was initially raised by the workmen, HN and Senior Trade Union who was working in the artisan in the establishment of Iman under the
Let me, the management witness number one, C. Omit Kumar, Assistant Personnel Officer, Engineering, Madu headquarters in his evidence category mentioned that the cadre strength book sanction of the respective category of the workmen of other staff as on 1/4/2003 has been prepared by the chief engineer Bridgeline White and Exhibit C. And the cadre strength of the respective trade category in respect of the workman has been worked out on the basis of circular Exhibit 1 and the letter number 6/1/2004 Exhibit B. And the statements are prepared accordingly by the Exhibit D. He also mentioned that according to the calculation, the post in the higher grades does not get created due to the restructuring as per the revised percentage. As such, no post was created in a higher grade in the trade of pleasure. Fitter structure, fitter mechanic, motor trolley driver and truck driver for which the claim of promotion to the workman and the other staff could not be considered. In his cross-examination, he also confirmed that the workman in connection with the referral has been given benefit of restructuring to the employees taking into consideration of the terms, condition, and after observing all formalities for which it took sufficient time, and more particularly the assessment of the conditions, namely matching, serving, regarding financial aspect, etc., and they have considered the entire list of employees at the time of providing restructuring benefits. On the other hand, the management in course of cross-examination of the workman witness as well as in the written argument took the plea that the artisan category under Deputy Chief Engineer Bridgeline Maligaon does not fall in the purview of artisan in other department. As such, the workmen are not entitled to any benefit of restructuring. This is clear. The restructuring of management witness number one and the plea taken by the management in course of the cross-examination of the witness and the arguments are contradictory.
But unless and until the posts are restructured, how there can be a direction for implementing? What you are going to do?
Yes, yes,
You are going to, if I understand one thing,
right.
means it's a very lengthy award. And you are also not properly existing the scope. But from what I could gather from reading it,
I have given a written argument, my lord.
your written argument is different. But the fact remains that there are 4 posts. There are 4 grades.
Right,
These 4 grades, there will be certain reduction in certain lower grade,
lower grade.
but the post remains the same in respect to the cadre. Just for example, in the artisan cadre,
My lord.
there are 100 posts. Of these 100 posts which are there, the lower posts or the lower graded posts have been reduced
Yes,
and certain higher qualified posts have been added.
edit.
Means grade 1,
Yes,
grade 2 have been increased, grade 3 and grade 4 have been reduced.
reduce.
That's it.
That's it.
But unless you implement that policy, how can a person get the benefit?
We have implemented, my lord.
Then why haven't you given the benefit to them?
My lord, our claim is that, my lord, while implementing, while carrying out the exercise, posts were not my lord, created. While,
So therefore.
while calculating the, my
How
lord,
could you, how, therefore my question is, if you are not creating posts in the higher
yes,
category,
yes,
how are you implementing it?
no, my lord. So far the creation of post will depend upon the numbers of, my lord, percentage. We, with reference to the, my lord, the post which was available in 2003. For example, my lord, page 42, if lordship see, my lord, again, my lord, in the plater cadre, artisan cadre, now, my lord, senior technique, tech.
Yeah.
My lord. Senior technician, my lord. This is 5,000 to 8,000. Initial earlier restructuring was, my lord, existing percentage prior to restructuring this sanction cadre. There's no post, zero. Therefore, if we calculate with the, my lord, revised percentage of 8, so for the senior technician cadre is concerned, then the post was not created.
But
This,
posts have not been. created.
yes, 5,000 to 8,000. That senior technician, my lord, this is the grade pay of senior
No, no,
technician.
no. It was earlier 5.
Earlier 5, now it is 8.
Therefore, are you not saying that
No,
you
this-
have reduced from year? You have already done it.
Earlier, matlab, before this was, the earlier was also, matlab, restructuring was carried out. That calculation was 5%.
You have
5.
not- you have
And
not done-
now,
Mr. Counsel, the judgment is also horribly made. You
Now,
are
my lord-
also not properly assisting. The best is to dismiss your petition. No, you are not saying what is wrong with the order.
no, that's correct, my lord.
No,
Now,
what is correct?
is wrong is that, my lord,
What is wrong? with
No, no, kindly
It's
say, my
like
lord.
this. What?
sanction cadre
Mis-
as on
mis-
1/3.
Mr. Dutt, the question is very simple. Unnecessarily, this matter has been sent to the industrial tribunal. It could have been done in a writ proceeding. You have come up with a circular of 9/10/2003, whereby you say that you are going to increase some posts in a higher cadre and thereby reduce some posts in the lower cadre,
By applying particular, my lord, percentage.
whatever percentage. You are going to increase some posts in the higher cadre, reduce some posts in the lower. And the reducing this, you are doing it so that the lower cadre posts which are there, which you are reducing, will be abolished. Meaning thereby, the posts which are 100 remains 100.
Right,
There's no change in that.
yes.
Post 100 posts remains always 100.
Upper level
respect to the
posts should have been increased,
Particular cadre of, just for example, placards,
my lord,
100 posts remains as 100.
100.
But what you are going to do, you are going to increase
Adjustment.
the grade, higher grades, reduce the lower.
Lower.
grades. Now,
That's-
my therefore question is
My lord.
whether this policy was implemented for artisans,
My lord,
then why these people are not getting the benefit?
my lord, so far these people are concerned, my lord, we are to act on the, my lord, while give, if posts are created, my lord, kindly see, senior tech 1, pay scale, my lord, 4,500 to 7,000. Initial, earlier, my lord, the post was number 2. My lord, sanction cadre, sanction post was 2. And then by calculating also, my lord, revised cadre, we found 2 only.
I don't understand what is this 02. You see, 35 existing prior to 9/10/2003 is 35. Isn't it?
Yes.
First column. The third column is
Consider as-
revised as per restructuring order 41.
Yes.
So there is an increase. by
Increase,
six.
increasement of, my lord, six posts. Correct, my lord.
Six. Now, what is this revised by 2?
Revised percentage, revised cadre strength as per restructuring order.
Then
Reverse
what do you
number
mean
of
by
posts.
that?
And this is increased by 6, my lord, also correct. And my lord, our cases, why, all right, even if the posts are increased, we have to give on the basis of their seniority. While granting to others, my lord, these people, their term that did not come. We consider them also.
Say that.
Yes.
Therefore, the question is, see, you are implementing,
Yeah,
but they cannot get the benefit unless and until
they come with it.
they come within the seniority.
Yes.
Now, where is the seniority aspect? Show me that.
Uh, that is also not been decided by the trial court.
Huh?
That is also not decided.
No, from the circular, show me to me.
Yes, madam. Page 35, madam.
Where?
Para 10.
Huh? Yes, yes.
10. The concept of multi-skilling is to be introduced by merging the different categories as mentioned here in the while the revised percentage distribution of posts as indicated in the annexure to the later should be implemented in the unified cadre based on the integrated seniority list. The duties, responsibilities and functioning being performed by the employees of the respective cadre will be combined in a phased manner. Each member of the cadre will have to be equipped with necessary skill functions through proper training and development. The categories indicated herein will have to be merged into integrating the seniority of the employee working the respective cadre with reference to length, non-fictitious service in the relevant grade, keeping the interest and seniority in the respective group intact. On the primarily the seniority is the basis. Even the when the post will be there increase, then on the basis of seniority we can give. Not as a different section wise we will implement this.
And you come page 29.
Malo.
Read the last paragraph. On perusal
On
of
perusal of evidence on record along with the documents submitted both the sites and having regard to the submission of the learned advocate for the management as well as the union office bearer together with the written argument, it is found that management has given some contradictory statements such as with their written statement as well as the written argument that the management has clearly stated the artisan category of workmen working under deputy chief engineer this line are not entitled to the benefit of the restructuring policy adopted by the railway board white number so and so exhibit 4. While management witness number 1 in evidence stated they are provided benefit of returning to workman artisan category due to the late receipt of the railway circular, mark exhibit 3 and 4, they could not take necessary step for restructuring of the workmen in time such. It is clear contradiction to stand on their leg. The management on the other hand stated restructuring benefit has already been extended to artisan category, but the workmen in the instant case could not be given restructuring benefit as the corresponding post could not be created to the higher grade in respective state as per the railway board circular mark exhibit 2, and it is clarification issued by the board from time to time. Restructuring benefit employee was taking into account the terms and conditions and after observing all formalities for which it took sufficient time and more particularly the assessment of the conditions, namely matching serving regarding financial aspect as stated by management witness number 1. But management have not been able to satisfy this court by producing relevant document as to effect that they have been implemented the restructuring board's decision issuing white later annexer exhibit 2 and the subsequent clarification issued by the exhibit 3 and 4. From the above circumstances, it is found well established that management have not been able to prove that they have given the benefit restructuring to the workers in the artisan category in terms of the instructions guidelines issued by the railway wide exhibit 2, exhibit 3 and exhibit 4. It is also well established that as has admitted fact the signal telecom department of NF Railway have followed the correct policy restructuring artisan staff by the exhibit 5. The management in course of argument took the plea that the establishment of the deputy chief engineer bridge line, Maligaon is not bound to follow the circular signal and the telecommunication department of NF Railway, but establishment of signal and telecom department, the open line organization and the establishment deputy chief engineer manager are working under the same umbrella. The Indian Railway, all these establishments are bound to implement the Railway Board's direction instruction in regard restructuring policy issued by letter number so and so. Hence, I found no force in the argument raised by Mr. K.C. Learned advocate for the management in this aspect. The union, on the other hand, pleaded that the evidence categorically mentioned that the workman artisan get under the chief engineer bridge line number have been deprived of getting benefit of restriction. They have discriminated by the management. And that the management pick up two workmen, see Deepak Das and the UC Das. This is a wrong analogy that we have given two numbers. If we have not given this then page 30, last para, discriminated by the management and the management pick up two workmen, Deepak Das and UC Das, and promoted them under the restructuring policy. And thereby the management deprived the remaining workmen in artisan cadre under Deputy Chief Engineer Maligaon. These two persons, these are also the Deepak Das and UC Deka, these two persons of this same establishment, Deputy Chief Engineer Bridge Line. Merely these two persons get and others did not get, This contention of the union cannot be thrown away since it is established that the other department, namely Signal Telecom Department, have fully implemented the policy. But once, let me read, the management witness, what he said, this is very important. Management witness, his version, page 22, para 6. The management of NF Railway, examine Omid Kumar, Assistant Personnel Officer, not NF Railway, headquarter, as management witness number, who stated that Railway Board issued circular exhibit 2 granting restructuring of benefit employees, and subsequently some clarification was issued by circular of even that 6/1/2004 regarding restructuring of cadre with reference to the strengths as on 1/11/2003, marked as exhibit B. He mentioned that cadre strength, book of strength of the respective category of workmen and other staff.
Usually, the enclosure to the communication dated 9/10/2003,
Yes.
enclosure D, E, statement regarding restructuring of Group C and D staff to all engineering departments, including workshop. Annexure to the board's letter dated 9/10/2003,
My lord.
artisan staff. This is what has been given.
Yes.
Then why you are not giving the benefit?
No, my understanding and the instruction is that while giving this benefit on the basis of seniority, these 6 persons now who were remaining, because 11%.
Where is your stand taken in your written statement? Show me. What you are saying out here is a different thing, but
Yes,
where is your
yes, yes.
stand in your written statement?
Man.
You have not taken that stand in your written statement.
Para 10, my lord.
That the statement made in para 11
The
of the.
petitioner not correct.
petitioner
As
not
per the
correct,
renewable
don't say that.
circular, restructuring was ordered for individual categories, not collectively for all artisan categories together. Hence, according to the strength of the each category, several percentage of distribution restriction was done as per prescribed percentage as ordered by railway board. For considering the cadre should have minimum required no number of staff to cover the prescribed percentage. In the instant case, the applicants do not have their individual category strength, the minimum
Is it
number of
different from
staff.
What you are saying on seniority basis? Is it nothing to do with seniority?
Here we say, my lord, in this
No,
case,
no, you have not mentioned a single word about the seniority.
my lord,
First of all, you must have not properly read your brief properly. You have not done just reading out here doesn't make.
my lord.
Here is a thing, your basic idea out here, as it could be seen from the written statement, is that look here, this restructuring is being done on the basis here, but that has to be sufficient number of availability in that particular cadre. There were required, the amount were less,
Right.
and as such, we did not do so. That is what has been the stand.
That's the thing, my lord. My lord, so far the seniority I submitted, in the event post is created, then we are to apply promoted on the basis of seniority. Now, in this particular case, our categorical strength is that while applying the revised percentage, post was not created. Therefore, this person cannot be accommodated. This is the limited submission here. And I
And
have
you have
given,
given benefit to some other people. That is the evidence.
no, these people, my lord, here this management witness has clarified.
So unless there is
So
a
that person is,
evidence, so therefore, if you are taking the stand, that look here, for this particular thing,
normal,
your thing is,
yes,
so considering the cadre should have a minimum required number of staff to cover
Right,
the
right.
prescribed percentage. In
yes,
the instant case, the applicants do not have the individual cadre strength, category strength or minimum number of staff to extend the restructuring benefit.
my
This
lord,
is your stand.
yes.
But evidence on record
Two numbers person were I
says
given.
that this was done. Then unless you show perversity in that, why should this court interfere?
Now, perversity on the basis of the example of 2%, this is wrong. This benefit is there, this is normal promotion, not under this restructuring.
No, but that is the evidence which have been discussed.
They wrongly read, my lord, that evidence, page 20, my lord, just kindly see, my lord.
Paragraph,
13 line, my lord, from the bottom, my lord,
Paragraph.
page 20, one,
paragraph,
only one para, my lord,
paragraph of the order award.
page 20, my lord, paragraph.
Paragraph of the award.
This paragraph is not there, my lord.
Award has paragraph.
Internal page, my lord, 9. Sorry. Oh, running paragraph, my lord. This is a long paragraph, para 5.
Yes. Which
It continues up to page 20.
Ah.
1, 2,
Then?
3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 13 line, my lord, from the down below, my lord. He pointed out, middle, my lord, down below. He pointed out that Sri Deepak Das was working as plater gate 2 in artisan cater in the same establishment, deputy chief engineer bridge line, who was promoted to plater grade 1 under the said policy of restructuring, while workman Banindra Chakraborty serving as plater grade 3 was denied that the benefit of promotion plater grade 2, grade 1 falling to be filled up in the due course. Similarly, UC Deka, Jagannath was working as fitter grade 2, we were promoted to grade 1 and in artisan cater, but to workman Ajuta Prasad, Sri Harikumal De serving as truck driver and Sri Raju Telugu motor driver. Peter was denied the benefit for promotion to grade 2 and then grade 1 in the various vacancies falling to be filled up in due course under restriction cater policy. During cross-examination. Workman witness. This is the workman. This is said by the workman witness, my lord. Now. But the management witness had said, my lord, page 23. So far, the appointment of promotion of Deepak Das is concerned, a normal promotion, my lord. Page 23, my lord.
So far I could recollect, the workman Iman as mentioned in serial of Exhibit 7 was promoted against normal vacancy and not
Yes.
under the restructuring benefit.
Yes,
and in
this
that
is the
regard, a
evidence.
provision was issued.
Yes,
I
the,
cannot recollect who was Jogla Harikishan without the record, as there was more than 1,000 workmen in the breach line. We
yes,
have considered the entire list of work who were employed at the time of providing restructure. It is not a fact that we have not followed the provision of restructuring benefit as provided in Exhibit F, and that we have taken into consideration the list of employees.
All
who
employees.
were cadres in giving not the fact that there are some cut off date.
this is our evidence, my lord. We have not given the promotion under the restructuring policy. So for this person mentioned in the award, my lord. But the workmen, they were claiming this appointment, promotion of Deepak Das was under the restructuring policy. And on that basis, the award was passed primarily.
P1 2025, 2005, the following year, that is Exhibit 7, found suitable for promotion to the post of tech IMA in the cadre in the modified selection is hereby temporarily promoted to officiate as grade 1 and posted as is where is basis different field under so and so dated 30/10/2003. So Deepak Das' name had been shown against that. The simple case is this. If we come to page 42.
Man.
This was being made by the person concerned who was the management witness number 1.
Yes. Calculation.
Yes.
And percentage, my lord, lordship will find in the exhibit I have given or in the my lord, written statement also.
Mr. Das, let me explain you have been totally unsuccessful in explaining the case to me for the last 1 hour, 10 minutes. The reason is there were no higher posts created. And as there was no higher post created in these artisan cadre of platter, fitter, motor and truck driver.
Right.
The question of these people getting a promotion therein does not arise.
That's the case. That's the case.
And all along you are going into the question of seniority or anything to that effect.
That's the case. Bless me. And given one written argument also, my lord might consider.
After hearing your argument, the written argument must be on the same line.
Yes.
Better off, let me not indulge in more confusion.
Right. Obligation.
So let me dictate it. I'll come back. Now you just see 35 sanction strength. You see, kindly come to page 42. This is interesting.
My lord, 42, my lord.
Yes. Of your,
My lord, this is, there is a confusion. I have to clear that, my lord. This is the calculation done so far this bridge line section is concerned. And as per the railway board, my lord, there was a modification of the existing number of percentage. So that percentage I did not show, my lord. That has created. On that basis, this has been, my lord, from the exhibit I have given, my lord, page 11, that the bunch of paper I have given,
no.
this is the, my lord, for the engineering department.
Have you seen exhibit B?
Yes. Yeah, that is the, my lord, heading.
That is 6/1/2024.
Right.
It has been decided to substitute the provisions in respect to the following appearing in a 1, 2, 3 of the board's letter and so and so. Date of the restructuring cadre will be with reference to the sanction strength as on 1/11/2003.
Yes.
The staff who will be placed in higher grades as a result of the implementation of these orders will draw pay in the higher grades with effect from so and so.
Yes. Now, my lord,
This
sheet
is
has
the-
been given down below, my lord.
Huh?
Down below, my lord, next page, my lord. Yes. Statement regarding restructuring in group sheet D, common to all engineering department. Was it found, my lord?
What?
So far the engineering department is concerned, this is the percentage, my lord. This has been modified. This is that calculation we found on this basis, my lord. I have given the, my lord, exhibit, page 11. So for the engineering department, this is the calculation on the basis we have to do.
What is that document?
This is exhibit 6, my lord.
Huh?
Exhibit 6, my lord. Annexure D.
Exhibit 6.
Yes.
Exhibit 6 are workman exhibits. Are you relying on workman exhibits or the management exhibit?
The WS kindly, this is the percentage, my lord, this was modified.
You don't have exhibit C.
On 9/10/2003, my
You are
lord.
not understanding, Mr. You see, page 42.
Our calculation.
Yes. This is overall. This is the overall strength.
Oh, yes, yes, correct.
And this 0 and 0
Hmm.
means there is no revision
Right.
out here. Sanction strength. Senior tech is 0. You
Right.
have to understand now, this is the sense. You see, 9/10/2003 is the date on which the restructuring circular came.
Right.
Then came first clarification on 6/1/2004,
Yes, yes,
giving it effective from 1/11/2003.
3.
As on that date, the strength was 0. Kindly come to page
Right, right.
42.
Yes, ma'am.
And revised strength was also 0. So therefore, there was no restructuring done for
Yes.
giving them the promotion.
Right.
This is your long and short case.
This is the Malad case, Malad. This is the case, Malad. Obliged.
Okay, let me come back.
Yes. Thanks, sir.
By of various type of service being rendered out. Petitioner herein have essayed the award dated 31/12/2014, passed in reference case number 07/2007 by the Central Government Industrial Tribunal cum Labour Court Guwahati, whereby for short the Learned Labour Court, whereby the Learned Labour Court passed an award, thereby directing the petitioner to implement the policy of restructuring and to grant the benefit thereof to the artisan workman category under the dy.ce. line Maligaon to 6 numbers of workmen, namely Sri H.K. Day, Sri Hariprasad Thakur, Sri Varindra Chakraborty, Sri Raju Telugu, Sri Adya Prasad, Aydy, Adya Prasad, and Sri Surindra Sahani, with effect from 1/11/2003, observing all instructions or guidelines for implementing the policy issued by the Railway Board's letter dated 9/10/2003. Letters dated 9/10/2003, 24/8/2008, 24/8/2004, and 17/6/2004, within 3 months from the date of receipt of the award after publication of the same being made by the ministry. First, the impugned award have been assailed by the petitioner on the ground that the Learned Labour Court have decided, have passed the award without taking into consideration that the said policy, the said restructuring policy implemented by circular dated 9/10/2003 would not be made applicable to the facts of the instant case. For the purpose of understanding, appreciating the dispute in hand, it is relevant to take note of the brief facts which led to the filing of the instant proceedings. The Government of India, Ministry of Railways, Railway, Railway, Railway Board, had issued a circular dated 9/10/2003. Bracketed the other, hereinafter referred to as the restructuring circular, restructuring policy, bracket close, inverted comma, close, bracket close, whereby the Ministry of Railways with a view to strengthening and rationalizing the staff pattern of the railways, decided that Group C and D categories of staff as indicated in the annexure to the said communication letter dated 9/10/2003 should be restructured in accordance with the revised percentage indicated therein. Thus, it appears from the enclosure to the said revised circular more particularly annexure E, that in respect to artisan staff, the revision was to be worked out in the following manner. एक on my by a yellow की मारा yellow की a It is further relevant to take note of that pursuant to the communication letter dated 9/10/2003 the Railway Board issued an order dated 6/1/2004 whereby the communication letter dated 9/10/2003 was modified, thereby the percentage distribution of posts in categories of shunting of drivers and diesel assistance of electrical assistant was to be revised from the existing 20:80 to the ratio of 30:70, and the percentage distribution of posts for the category of technical supervisors for the category header where mysteries posts, mysteries, MISTRIS, mysteries posts are not existing should be revised from the existing 17:28:25:30 to the ratio of 21:29:24:26. Further to that, it was also mentioned in the communication dated order dated 6/1/2004 that the restructuring of the cadre will be with reference to the sanction strength as on 1/11/2003. and the staff who will be placed in higher grade as a result of the implementation of the orders would draw pay in the higher grade with effect from 1/11/2003. The record reveals that one Hari Kamal De, along with 16 others who were employed in the artisan cadre in the establishment of the Deputy Chief Engineer of Bridge Line Maligaon, Northeast Frontier Railway, under the control of the engineering department, headed by the Principal Chief Engineer, and occupied and being employed in separate trades, all classified as artisan cadre, both for general purpose of personnel management and in restructuring cadre, had submitted a representation being aggrieved at being left out from the benefits of restructuring of the cadre. The said aspect was placed before the Regional Labour Commissioner C. Guwahati for conciliation. However, the conciliation failed, which resulted in a reference being made by the Ministry of Labour by order number L-41011/3/2007-IR bracket B-Roman 1 dated 28/6/2007. The reference thereupon was modified by an amendment on the basis of a ministry's order number L-41011/3/2007-IR bracket B-Roman 1 bracket close dated 3/9/2009, which reads as under inverted comma, whether the action of the management of NF Railway in not giving restructuring benefit to Sri Hari Kamal De and 16 others with effect from 1/11/2003, 1/11/03, by order number PC/Roman 3/2003/CRC/6 at dated DT 9/10/2003 is legal and justified, inverted comma close. Pursuant to the said reference being placed for adjudication before the Learned Labour Court, written statements were filed by both the parties and evidence led. The Learned Labour Court, on the basis of the evidence, on the basis of the pleadings as well as the evidence, decided the reference in favor of the workmen, holding inter alia that the order number PC.Roman 3/2003/CRC/6 dated 9/10/03 and the clarification issued thereon was illegal and are not justified. And the workmen, more particularly only 6 in number, names of whom have already been referred to herein above, were directed to be given the benefits of the restructuring policy with effect from 1/11/2003. It is under such circumstances the present writ petition has been filed before this court. This court, by an order dated 5/8/2015, issued notice and state the award dated 31/12/2014 passed in reference case number 7/2007 by the learned labor court. The interim order thereupon have been continued till date. The record reveals that in spite of various opportunities being given, the respondents have not appeared. And resultantly, by an order dated 5/6/2025, this court have duly observed that one final opportunity was granted to the respondents to appear in the matter, failing which the instant writ proceedings would be taken up ex parte. In spite of that, the respondents have not appeared. When the matter is listed for disposal today, and under such circumstances, the present writ petition is taken up for disposal. Mr. P.K. Das, the learned counsel, appearing on behalf next below, appearing on behalf of the petitioner, submitted that the impugned award suffers from perversity, taking into account that the learned labor court completely misconstrued the policy in restructuring policy dated 9/10/2003, as well as the evidence on record. And as such, the impugned order is required to be interfered with. This court have duly taken note of the restructuring policy dated 9/10/2003, whereby the Ministry of Railways had decided that the Group C and Group B categories of staff, as indicated in the annexures to the letter to the letter dated 9/10/2003, should be restructured in accordance with the revised percentage indicated therein. The record further reveals that in respect to that, pursuant to the said letter dated 9/10/2003, certain modifications were carried out by another letter dated 6/1/2004, whereby the restructuring of the cadres were to be made with reference to the sanctions cadre strength as on 1/11/2003. This court in the previous segments of the instant judgment have duly noted about annexure E to the letter dated 9/10/2003, wherein the restructuring pattern in respect to the artisan staff have been mentioned. This court further duly takes note of the Exhibit C, which categorically stipulates the post sanctions in various amongst in the artisan cadre along with other posts. Annexure D, Exhibit D, is a document of vital importance which stipulates which mentions about the change in the revision, change in the cadastre pursuant to the revision as per the restructuring policy on the basis of the letter dated 9/10/2003. This court have also taken note of the evidence of the management witness number 1, wherein in uncategorical terms it had been mentioned that in view of the sanctioned cadastre as on 1/11/2003, and the letter dated 9/10/2003 being worked out, it was found that no post in the higher cadre was created due to restructuring as per the revised percentage in the trade of, in the higher grades in the trade of plater, fitter structure, fitter mechanic, motor trolley driver, and truck driver. It was also categorically mentioned that in view of no higher post being created, the question of granting promotion to the workmen and other staff cannot be considered. This court have duly taken note of the impugned judgment and order the award dated 30/12/2024, 2012-14. And it appears from a perusal of the impugned award that the learned labor court completely had misread the evidence, misread the evidence, as well as the policy, the restructuring policy, as mentioned in the letter dated 9/10/2003, as well as the order dated 6/1/2004. The learned labor court failed to appreciate that when there was no post created in the higher cadre, the question of the workmen being promoted to the post in the higher cadre could not have been directed. The emphasis placed by the learned labor court on a person, namely Sri Bogdas, being promoted against the restructuring policy. On the basis of Exhibit 7, was not wrongly, was not properly taken into account, in as much as on the basis of a corrigendum issued subsequently, it was mentioned that Sri Deepak Das was promoted against a normal vacancy. Considering the above, it is therefore the opinion of this court that as there was no higher post created, the question of the workmen being given the benefit of the restructuring policy by giving them promotion to the higher post did not arise. And under such circumstances, the impugned order having failed to take into consideration the evidence on record, as well as have misread the letter dated 9/10/2003, as well as the order dated 6/1/2004, suffers from perversity, for which this is a fit case for interference. Accordingly, this court therefore disposes of the incident with petition. Therefore, accordingly, this court therefore sets aside and quashes the impugned award dated 30/10/12/2014, passed in reference case number 7/2007 by the learned labor court. Labor court only hetu likhi dibo, Central Industrial Tribunal come labor court. The records be returned to the courts below.
No obliged, my lord.
Item 9 and 10.
What is this? FCI.
Petitioners in different cases, my lord.
Huh?
Both are challenging the same, my lord, the award.
Both are challenging the award.
My lord.
Why?
Because one benefit, my lord, was not given to us as far as regularization is concerned. And the benefit of bonus was given, my lord, that the FCI.
Huh?
The benefit of bonus was given, my lord.
Management shall pay the bonus to the concerned worker involved in the reference with effect from demand as per applicable rates till the date of the award. The payment of the bonus shall also continue thereafter till such date the concerned are in employment of the benefit. In regard to non-payment of overtime, now benefit shall also pay. Or however the consequence. So you are challenging the bonus and
Bonus
overtime.
part, man. Bonus part, man.
Bonus and overtime.
Bonus and overtime.
Overtime. And he challenging on non-granting of the regulation.
Yes.
Now, who are you?
Well, I am representing Food Corporation of India.
Okay.
And the other side is a workman.
Regularization of 3 workmen out of 10 in fair labor. Are they working still?
My lord, they are casual workers on need basis, my lord. Whenever there is a spillage of food grains in the FSD, they are engaged, my lord.
No, I'm asking, are they still working?
Still working in the sense that as a casual worker. Whenever the
Regularly?
not regularly, my lord.
No.
Whenever the need is arises, my lord. Whenever there is a spillage of grains in the FSD, they are engaged for collection of that grains, my lord. Casual workers on the need basis only.
How many workers?
There are 6, my lord, out of which 2 have is now over 60 years.
Over?
60 years, my lord. And the respondent number 3, that is Babul Das, is 58 years. Respondent number 4 is 55 years, 5 is over 60 years, and respondent number 6 and 7 are respectively 56 and 53 years.
Retrenched. You're
They were
retrenched.
earlier retrenched, my lord. Now that was interfered into, my lord, because that
25B.
25F, my lord, that
Then-
was not followed. So they were again were engaged, my lord. Now in the year after their engagement, my lord, in the year 2007, 2005 they approached a by filing a writ petition for their regularization. The Honorable High Court, by judgment dated 18/7/2007, has directed them to approach the industrial tribunal, my lord.
Hmm.
That judgment, your lordship will find at page 58 of the affidavit in opposition filed by the respondent, my lord.
You did not adduce evidence.
We have not adduced it.
So what you say cannot be therefore taken into account that they are regularly, they are not casually only for when the food grains, there's a surplus of food
Yes,
grains,
ma'am.
then only they are engaged. That cannot be taken into account as there is no evidence from your side.
But they have also not been able to prove their case, my lord.
No, forget
With regard to the bonus,
Forget
ma'am.
about them. So your stand that they have been not properly, uh, they have not been regularly means on continuous, not regularly, continuously not employed is not a thing which you can substantiate before the scope.
Only through written statement, my lord.
No, written statement is pleading, is not proof. So that is that your stand that you are continuously
My lord,
well,
since 84, my lord. Since 1984, we were retrenched once, my lord, but then that was interfered with. The matter traveled to the apex court, post dismissal of the SLP. We were, my lord, reinstated.
let's see that work judgment of the division bench.
Not that for regularization part, my lord.
No, retrench.
Retrench.
As far as the retrenchment is concerned, my lord, is at page 52, my lord.
52, my
Page
Huh?
52 of my
affidavit in opposition.
affidavit.
62.
Sorry, my lord, in page 52 of my writ petition, my lord, the second writ petition. It's 2092 of 20.
By the implement of the food has retrenched the services of 9 casual workmen of remand and 1 workman to an workman. They have been working for the last 10 years as on when the judgment was pronounced in 2001.
My lord.
For the last 10 years at that point of time, and you were employing them in the ratio of 19 days in a year, month. Thereby not completing the, if it is 20 days, it becomes 240 days.
Yes.
So you have been employing them for 222 days. Well, you have been employing them from around 222 days. 20, 20. And your basis is that they are not, therefore, do not come within the ambit of a work. That was your case before the earlier round of litigation.
Yes.
And the court and the division bench held out here that look here, the question does not arise. This only would have applied in a case where a person had only worked for 1 year. But here is a case where the person has been working for the last 10 years continuously. So therefore, the question does not arise. So they come, you have to, the retrenchment was illegal by definition. Now thereupon, you have been again employing them for again 19 days in a month.
Not exactly, madam. It is not on record whether they were engaged for 19 days in a month, madam. They were engaged on the need basis only. Whenever there was a handling work arisen in the.
No. That was your stand in your written statement before the learned tribunal. Kindly see page 50 of his writ petition. Before the
Yes, ma'am.
tribunal,
Paragraph
it
11.
was filed by the management. The stand taken by the management is as
Yes,
follows,
ma'am, it
that
is there.
none of
19
the
days
regular
only in a month
employees of
and they
so-and-so
work.
and were engaged for more than 240 days in a year from their date of engagement. Their engagement was made 19 days in a
19
month.
days only in a month.
So that means they were working, as per you, they were working for 228 days. Now, the tribunal holds finding is this, that these 240 days concept would not apply, taking into account that these people have been working for the last 10 years in this manner. And this has been further affirmed by the division bench. Kindly come at page 53. The submission made by the learned counsel is devoid of any substance. The period of work of 240 days shall be taken into consideration in the case of a workman who has worked with a company for less than a period of 1 year. It is for the purpose of the calculation of year service. 240 days are to be taken in consideration where the workman is employed in the continuing year. Therefore, has no application if the workman is working continuously with a company for more than a year. We do not find any illegality or infirmity in so and so. So that has attained finality. Now, therefore, the next question comes is another petition being filed by you.
By the workman,
No, that annexure 9, page 58.
my lord.
This is being filed by whom?
By the workman,
By the workmen. Asking
for
for,
their regularization.
and then the court said what?
My lord, page 64, paragraph 15 and 16.
It should be made clear that non-entertainment should not be, but appears from the materials on the regulation except was initiated by respondent as a one-time measure in the context of the return prevailing at the time of event. May not be the case for us this court direct without the Now, Umadevi's judgment has been clarified, I may say so,
My lord.
by the Supreme Court in the recent judgment where they have been granted some regularization.
My lord.
What is that name of the judgment?
My lord, there are a series of judgments, my lord.
The last of the series. Haram Singh.
Sripal, Vinod Kumar, and my lord, Jacob. There are three
Huh?
decisions. There are three decisions, my lord, in my notice.
Which are,
These are the three members.
what are the name?
Sripal and another was the Nagar Nigam. Then got Vinod Kumar. And Jacob.
And?
Jacob, my lord. Jacob versus Nilin. Okay.
Why not the Dharam Singh? You don't like that?
It says that Uma Devi was rendered in a particular condition that, yes.
No, no,
you should not-
Uma Devi is different.
my lord.
Uma
Here,
Devi is
question of my lord,
different.
continuous engagement
No, no,
for
why you are
year
not
after year, my lord.
You see, the main is Uma Devi, that Dharam Singh is a similar type of matter here. Wherein their benefits, certain benefits were being given since the day on which they should have been regularized. Now, why are you against the bonus?
My lord, actually, there is no bonus system in the FCI. It is a incentive, my lord.
Huh?
It is an incentive, my lord. Incentive given to the workers. If they,
No, 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 no. Bonus. You see, these people get the bonus under the Payment of Bonus Act.
Bonus Act 1960.
So the Payment of Bonus Act, doesn't it include the workman? Workman has been defined there also. To mean the person who will come within the ambit of that, what you call, where's the take on Payment of Bonus Act? Will come within the ambit of the Industrial Disputes Act, isn't it?
Yes.
So then why are you filing these type of cases? You know, Mr. Singh. Just for the sake of filing.
actually, the evidence was not led that
No,
they were
forget
not
about
given
evidence,
the,
forget about
they
evidence.
were not
No,
given
no.
the bonus.
Forget about evidence. Me. That the division bench categorically held in the case of these people that they are workmen. And if they are workmen, they are entitled to the bonus as per the Payment of Bonus Act. Where the workman definition is what?
The employee definition, my lord, not workman. Employee definition as section 230.
To
Section 230.
any person other than any appointed employed on a salary not exceeding 20 per month of employment and to any skill or skill for the industrial dispute. Every employee, section 8 of the Payment of Bonus Act, shall be entitled to be paid by his employer in an accounting year bonus in accordance with the provisions of this act, provided he has worked in the establishment of not less than 30 days in that year. So, there is no evidence to the effect that they have worked less than 30 days.
That is correct, ma'am.
Then where is the question of bonus? Challenging the bonus. You have asked them to work on a national holiday. Obviously. Mahatma Gandhi Jayanti, Republic Day, Independence Day, we have asked them to work. Are they not entitled to overtime?
Well, Out, out of record, that may not be correct also because on the working on the national day, because the officer will also have to be present on the national holiday, my lord. That may
Who?
not be correct, my lord. That their claim that they have worked on the national holiday may not be.
There might be a lot of more FCI things that when you maybe have a handling of this the grains, and the grains cannot stop on a national holiday, the pouring of the grain. Although we have certain holidays out there, but then also, just for example, the police has to work, the army has to be in vigil. Everybody has to have work. Mr. R.R. Gogoi's department, excise department, is the only which does not have anything to do on a national holiday. He may say, anybody who's saying out there, or any of the bonded warehouse may say that okay, there cannot be any work. But other departments,
That assessment is to be made. We were only found to be entitled. The exact number of days and calculation they have to my lord.
that
Might have worked, might not have
or
worked.
is no fact remains that they have been working. There's no evidence that they are working for less than that. So your petition does not survive. Now, therefore, I think, Mr. Singh, you come to this side
Yes.
and ask him to be there. So then I can grill him
Yeah, yes.
more on the question of regularization. But he has not brought the Dharam Singh's judgment. Mr. Pathak,
Right, huh?
what do you say? Got the judgment?
Got it. All by Justice Vikram Nath.
Huh?
All of this, my lord, by Justice Vikram Nath.
All the
Got it.
and this judgment takes care, looks into all these three judgments and then gives certain benefit. This is a very important judgment because the facts seems to be similar. There was a request being made at that point of time. There was a decision being taken at that point of time in that judgment whereby certain persons who were there, they were made permanent or regularized, but rest were left out. Isn't it that your case also? Some were left out. You were left out.
We were
whereas
left
the
out, my
others
lord.
have been regularized.
My lord, at the critical moment, we were retrenched, my lord. When we were fighting.
Here, what benefits have been given? Why it is very relevant is date. If you see the last of the certain directions which have been passed, those persons who have retired also, they have been also given some benefits. G or something.
Everyone who has already retired will be granted regularization with effect from 2002 until date of superannuation. For pay fixation areas under clause 3 and the recalculation of all pension and pension.
Ah. This is your point. These other three judgments, they do not tackle this issue.
My lord. They simply say that it has to be reconsidered.
Huh?
They simply say that it has to be reconsidered because they are continuously working.
And this was a case where these people were working. Find it out there. Judgment helps you.
19th August 25, escape my 19th August 2025, very recent. So I probably somehow escaped it.
This is the important judgment on it. More particularly, these were, you see, Uma Devi case is another aspect. Uma Devi, as could be seen from this recent trend of judgment, see, those people who have been working post Uma Devi, the difference.
My
But the fact remains here in this case. Since 1987, these people have been working.
84.
84. So for them, so they're similar. These people were working from 1989 or something.
Well,
in Dharam Singh.
yes.
So therefore, and at that point of time, there was a policy. In 87, they had a policy. And, but the only question is, you had a right of regularization, you challenged it by filing a registration. The court said that the court is not going to pass a direction for
In view of Uma Devi.
regulation.
And the court also said that you can approach, however, under the industrial laws
Industrial
to the
code.
competent court, and therefore this reference was.
Understood? You can approach the industrial law. But by passing order, would this court not be setting over that judgment passed by the learned by the
Now-
learned bench?
Now this court is sitting in 227, madam.
They're not sitting in 227. This court is sitting on 226. How do I take care of that?
Because Uma Devi has also been read down, madam. Uma Devi, those
Understood.
directions have been read down subsequently.
Yeah, in fact, in one of those judgments, I think Jago or Sipal, the Supreme Court says categorically that Uma Devi has been taken as a judgment, thereby to deprive the people, which is not what it is.
That is also equally.
Uma Devi was a, if you read paragraph 3, which is the most important paragraph for all types of litigations which comes, because prior to that, the judgment of Uma Devi makes it very clear that there is no question of regularization. The regularization concept is different.
Right.
It's illegal. You cannot regularize them. Subsequently, after Uma Devi, there are 2-3 judgments whereby it was said that you can regularize somebody who have been irregularly appointed. Not to a person who have been
Illegally appointed.
absolutely illegal. This has been further after 2, 3 or 4 judgments have been taken into account. Then comes the judgment in the case of District Bar Association Bandipora. 2017 yes. That's a 3 judges bench. This is a very important. The Uma Devi is 5 judges. This is 3 judges. But the remaining all are 2 judges. So these 3 judges judgment says that you cannot reopen anything to that effect, or even there cannot be any direction passed by the court. And further re-emphasizes another very important thing. Yes, you can regularize only to the extent it has been irregular. Now, there is one judgment in 1997 whereby it has been mentioned what is irregular and how can there be a regularization. That is, I think, Aluwat or something. But subsequent to that, in 2017, these series of judgments which have come that Uma Devi cannot be. But what one can understand, this in Dharam Singh, a very important issue. The question as to whether a person can be regularized or not is not justiciable under 226. But the fact that they are not creating a post, being a state, and were allowing them to work for the last 20 years is justiciable. This is a separate thing which comes out now in view in the paragraph 6 of Dharam Singh. You prepared it properly. This is how you have to take it out. On the first day after sitting out here, I don't want to dismiss Mr. V.K. Singh's first petition. His requisition is going to be dismissed because his payment of bonus does not arise. Overtime does not arise. That part of the award cannot be touched. Now the question is, both are tracked together, therefore, deposit of another day. Look into this Dharam Singh. Do you have any? Can you make out the case? Because that is, and I have to give him also, because he is also upon an understanding that some of the respondents are now 50, 55 years,
Right.
but most of them have retired.
Two of
So
them. my
therefore, the question is, he also has to look into Dharam Singh and try to distinguish, because there was a direction out there to give them the
Even
regulation
retired
with
persons were given.
the date and thereby giving them the benefit. Have a look at it.
Yes.
And have a think, okay, when can we have it? Otherwise, you could have been finished. I don't want to give Mr. Pathak a cakewalk by not
Yes.
reading the judgment and then
Yes, ma'am.
me helping him.
Fourth November, madam.
4th November.
No.
The matters having been heard at length, it's the matter again on 4th of November 2025. For the hearing. Showing it at part. It does
Obliged,
not
ma'am.
tell over it. Mr. Singh, you look into that aspect also.
Yes.
In this court, taking into account that there was a dismissal on the basis of Uma Devi, and this court do so, that whether that court was, the labor court was justified. And because the labor court said that they did not take any recourse. The regularization concept was rejected only on the ground that no recourse was taken by you after the judgment of Justice Rishikesh.
No, no, my lord. After that, my lord, the reference was made. So in
Understood.
2019, that was in 2016.
That
The
was
labor
after a long
held
time.
in that. The labor court held it in that. That is why it was rejected.
And also that there's no evidence as far as 240 days is concerned. However, the earlier finding, my lord, which was, my lord, at the time of our retrenchment, there is already a finding of 240 days, and the evidence is also there to that extent that, in fact, at that point of time, they were working for 240 days.
240 days.
My lord, that is also on record. So therefore, my lord, our writ
But
petition-
That was our contention that they have not worked for 240 days. That was rejected. It's not that they have worked for 240 days.
no. But the fact
Rejected
remains that there is a
on different
finding passed by the earlier court that this is final, that they have been working continuously for 10 years.
Right.
It's a finding of fact.
Yeah.
And that was in 2001. Thereafter also you keep on employing him. I'll help you more than that. Anyway, you
Right.
look into that.
Obliged, ma'am.
Item 11.
Wait,
Yes, what is this?
this is regarding my lord, closure of an IMFL on shop.
IMFL on shop is being closed.
Yes, my lord.
By whom?
By the excise department, though on the basis of a report furnished by the district SP Nagaon, my lord. The fact is that, my lord, I have obtained a license in the year 2011, and I have started the operation of business in the present location from 2021 in a plot of land inherited by me from my father, my lord. So there is a dispute regarding that land, my lord, with my elder brother. So after I have started operation, they started complaint against my IMFL on shop. First complaint was filed in the year 2021. Then a report was given by the excise authority stating that the licensed premises situated in a place which is in compliance with the excise norm. My lord will find the report at page annexure 22, page 30.
You stated
Yes, my lord.
That has been disclosed.
Yes, my lord.
You
We have allowed them to open the house, not to operate the on shop.
wine shop.
Yeah, the on shop, we have asked them not to operate, but we have unlocked the premises of the house.
Why not the restaurant?
Because there's complaints, there are law and order situation, and you asked report from the SP. SP is still saying that there are law and order situation arising if the moment it is open, your lot.
And has the SP filed an affidavit?
Yes, yes, madam. Yes, madam.
What does the SP say?
SP also say
There are
the same thing. madam.
some cases have been brought in here.
Law and order situation cannot be in perpetuity, my lord.
Some
Because-
injunction is going on.
Yes, my lord. When the report was in favor of my, then my lord, my elder brother filed the title suit
Hmm.
seeking injunction against my operation of the on shop,
Wine
that
shop.
wine shop, my lord.
But then,
That was also rejected. After that, other similar complaints filed by some other people, my lord,
Hmm.
influence with my elder brother. Then, my lord, ultimately, some
bail is
al- altercation was there
why bail?
because, my lord, there was an altercation outside the on shop.
Hmm.
Some people came and there was an altercation with the girl working outside the on shop, my lord. There is a juice bar, my lord, outside the wine shop. There, my lord, there was an altercation and FIR was lost. The employee of the shop, my lord, and the cross FIR was lost by the lady, my lord, who came there, my lord. So ultimately, they also took bail, my lord. We also took.
This affidavit. Affidavit by respond number 6.
Yes, six is my
Okay. That is the SP.
six is the SP.
Huh?
Yes, my lord.
Respond is the SP.
SP, my lord.
Public complaint was received with regard to the other regarding the nuisance created by business will come in before. Then why you have not cancelled this license? If this be so.
No, my lord, they have not cancelled.
We have
That's
cancelled it,
complete.
Lordship, because there was inquiry again conducted by us, the Lord. Now the inquiry says, though there are minor violations are there, but due to the alteration between the employees engaged in the petitioner's on shop and the residents, the police authorities have asked us to close down that on shop, the Lord. They also closed down because opening it again, the same issue will arise.
Alteration between whom?
Between the some of the complainants and the employees of this on shop. And further, as per the affidavit filed by the Superintendent of Excise, it says that there is an employment of girls who are below the age of 18 years old.
Employment of?
Of a woman, girls who are below the age of 18 years.
What
At-
is the woman doing in the bar?
At page 106 of the affidavit in point
Huh?
file, Your Lord.
CBI inquiry.
It is given by the Superintendent of Police.
All these are understood, but what are you doing?
Lordship, We are awaiting a report from the police. The moment they say yes,
Police has given these type of reports to you.
yes.
What
but
are you
thing is
doing?
that until and unless the law and situation, the police won't, if they don't allow us to.
No. First of all, your excise rules categorically mandate that it cannot be near to a hospital, near to a what you call school,
Yes.
Amgor, and a campus.
Yes.
What have you done?
We have given a report.
That's no, that's the report being given by the SP.
Yes.
The SP's affidavit. Kindly see the SP's
We have
affidavit.
given a report page 97, your lordship.
No, kindly see the SP's affidavit which is there. This at page 4. It's pertinent to mention that Greenland Bar cum Restaurant is situated in a residential area where school Namgor and one Kali Mandir exist. What are you doing? And this the temple, whether the school was prior to this or after this, are you not required to look into
That
it?
report we already submitted. Inquiry was closed. We submitted report to the Superintendent of Police at page 97. That we have filed.
This is being given by the superintendent.
Superintendent even this page 54 that this is the Superintendent of Police to District Magistrate.
Ah.
Thereafter, at page 97 of the affidavit in opposition filed by the Superintendent of Police, the Superintendent Excise,
What do you say?
it says inquiry report of MS Greenland cum bar restaurant Sri Surite Dimoguri Nogao. If I may read the lordship. The defense subject I have informed you that the undersigned had carried out the inquiry at the premises of INFL pawn shop restricted to Surite Dimoguri so and so. Number 1. As on date, distance of INFL retail license MS Greenland cum restaurant Surite Dimoguri from nearest education institute hospital with respect to norms set by Assam 2016 is more than 150 meters, which is in compliance with Rule
So this
289.
is in compliance.
Yes. Second, in this regard, report from the Dhiman Hazarika, ACS का measurement of dated so and so has also been seen where distance of IMFL shop from religious education hospital, dark number Patta number land, where the IMFL on shop premises is situated, issue and drainage are clearly addressed. The undersigned found that the present situation arose due to an alleged scuffle between the licensee and his staff with few neighbors outside the IMFL on restaurant. However, as per inquiry, no activities of violation provision set by
But you can't keep it closed, but you have to take a decision.
the thing is that we have the petition recently submitted another petition asking for review of this.
That
whole-
was given by the
No,
review,
this-
that order was passed by Justice Sumitra Saikya on 11/4/2025.
Yes, we have opened his. We have asked him. The thing is that he's saying the wine shop, the on shop, and his house is together, located together. We have closed on everything. We have opened his house, but the on shop, until and unless there is the police gives a clearance report that no, it can be open, it can reopen. We can.
But you have a power to close down the
There's an order came
restaurant.
from the magistrate law.
If they don't sell the liquor,
There's an on shop law. And the further is that, and another allegation.
let's come back at 2 and
Right.
further deliberate on this.
Okay.
Let me.
Now, what is your final prayer out here?
To set aside the order issued under section 52, my lord. And allow me to operate the on shop.
Residential has been allowed by the law.
Yes, my lord.
So you say that this has been done at the behest of these two officers,
Yes, my lord.
police officer,
Yes, my lord.
who is representing the police officer. In person, they have been issued notice.
No, my lord.
You are alleging malafide against him. Considering the submissions made and also in view of the contentions raised by it is seen that the superintendent and he have been arraigned as parties in the issue and this court notes considers necessary to issue notice at this stage. Till the responses by official respondent refrain from issuing notice to respondent number so and so. On one hand, in that order dated 11/4/2025, there are two aspects.
Yes,
One say that they for issuance of notice upon 18 lakh, and again says that not to issue.
yes, my lord.
So which should we accept?
My lord, today regarding my lord, the impugn order, I would like to submit regarding the impugn order first, my lord, because the impugn order was issued under section 52, my lord. And for issuance of order under 52, there is a requirement under the law to serve a notice. That has not been done, my lord. Well, kindly have a look.
Where is the impugn order?
Page 45, my lord. The order dated 16/12/2024.
So this has been done without notice.
Yes, my lord. On the basis of the report of the superintendent of police, this impugn order has been issued. And section 52 stipulates that the closing of retail shop for the preservation of public peace. The district or subdivisional magistrate may, by notice in writing to the licensee, require that any shop in which any intoxicant is sold by retail shall be closed at such times or for such periods as such magistrate may deem necessary for the preservation of the public peace. There has to be notice, my lord. No notice has been issued to me before issuance of this impugn order, my lord.
And as per the report submitted by them,
Yes, my lord.
except a scuffle between some employees of yours along with some other person.
Yes.
There's nothing else.
This employment of this lady in this bar, your lordship.
Huh?
That's the employment of a woman in the bar, as per the report of the SP, your lordship, who is below the age of 18. Which is affidavit which we have filed at page 97, which says that at 106, your lordship. The third paragraph, 106.
No, this is by the superintendent of police.
Yes.
But in spite of that, your decision which have been taken is not based on that.
Yes, my lord.
Your decision is not based on that aspect.
That was a subsequent report, my lord.
This is a subsequent report.
Yes,
That was a subsequent report.
One was working as cook.
You have read it?
Even section 52 clause 2, it says that if any riot or unlawful assembly is apprehended or occurs in the vicinity of any such shop, any magistrate or any police officer above the rank of constable who is present may order in the order the person in charge thereof to keep it closed for such period as the magistrate or the police officer may think necessary.
But the period has almost been 10 months.
10 months. Thereafter, inquiry was conducted, reports were called in. Now, after, at page 102, the excise is submitted another report, Your Lordship, of the affidavit. We have page 100, Your Lord, annexure F. It is submitted by the Inspector of Excise and Assistant Commissioner Nagaon. Annexure F, page 100, Your Lordship.
There is no major violation.
There's a
In fact-
at 102.5. Page 102.5. The subparagraph.
That is also say that it is outside the register.
9 out of 4 complainants. There are there are 4 out of 9 complaints are found to be residing within a distance 75 meters from the IMFL on license, namely Dipali Das, Rekha Mohan Das, Nikita Das, and Dulu Das. And this Dulu Das, as per mentioned, name is mentioned here, is the person who was involved in a scuffle, Your Lordship.
It was found during inquiry that Montudas and Tono were presently not residing in the locality and shifted. Hence, they cannot complain. And also the complainer Vibhadas and they used to reside outside the Imba. When the distance was measured with Potambara, it was outside. Therefore, only 4 out of 9 were found to be residing within a distance of 75 meters from the IMFL Iman. That is Dipali Das, Rekhamani Das, Nikita Das, and Dulu Das.
Dulu Das.
Then
This Dulu Das is the person who had a scuffle between with the staff in the staff, Your Lordship. This is the person who had a scuffle. Thereafter, this order was passed for closing down.
first of all, is that in the residential location?
It's a resident, the area is a residential lordship, residential location.
So do you permit in residential
They have to
location?
take the NOC, Your Lordship. 75 meters radius, people who are residing in 75 meters.
And you have no problem in giving the license since 2011?
Yes,
Because in 2011, that 75-meter issue was not there. That have been amended a lot.
Understood.
Yes.
So after amendment, how many shops have you shifted? We shifted any shop?
Because we have not received any complaint from any part of the area lordship. This complaint was merely because there was a riot, not riot, actually, there was a scuffle between the staff and the residential areas. Thereafter, the complaint was received.
Maybe because they are using loud voices, loudspeakers and all.
no, my lord. In fact, regarding loudspeaker also, there is a finding, my lord. That complaint was also
Because
there, my
it
lord.
become a havoc.
For
Nowadays, you don't have anything. Every time there is a loudspeaker.
uh,
Any program.
0.4,
anything
my lord.
Outside, you just go out there, there's loudspeaker. Music is being run like anything. People can't sleep at night.
because my lord, bar license is allowed to operate till 10 o'clock, my lord. So
But then also, if you are having it in the residential area, you cannot put loud music.
that complaint is also, my lord, otherwise negated, my lord, in the report. Though there was a complaint that there is a using of loudspeaker, because that has been done only on the ground that, my lord, some
But
people doesn't want
whatever
to.
Maybe you have received, you have got everything. What are you doing? Either cancel the license or go ahead with doing something. You can't keep him just hanging out there.
Yes, Your Lordship. They have, I pray, Your Lordship. He has already submitted a appeal before the commissioner, Lordship. Let the commission take a call because most of the inquiries have been completed. Let the commission take in account all the inquiry reports. Let him pass out a speaking order in a stipulated time. either to cancel his license or revoke the cancellation order, suspension order. Because he's already preferred an appeal before the Commissioner of Excise. And now the issue is that excise is.
Only thing is, my lord, under section 452, there is a requirement of law to issue a notice before issuance of suspension order, my lord. That has not been done, my lord. In the face of it, my lord, this order cannot stand.
But what about the second para?
Yes, my
second
lord,
con-
yes, yes.
You can do-
It would go.
In any riot or unlawful assembly is apprehended or occur in the vicinity of any shop, any magistrate or any police officer above the rank of constable who is present may order the person in charge thereof to keep it closed. To keep it closed. For such period as the magistrate or police officer may think necessary. This is not for indefinite period, my lord. Provided that no shop shall be kept closed under this subsection for a longer period than 48 hours without the order of a magistrate. So if magistrate order is required, my lord, then my lord, section 52(1) has to be followed. Noted
No,
as-
no, this B. Provided that no shop shall be kept closed under this subsection for a longer period without the order of the magistrate. So the magistrate has to then pass under one.
Yes, my lord. Then section 1, subsection 1 has to be followed.
So here, the district magistrate passed the order.
Yes, my lord.
It is under 52(1).
52(1).
It has not been done by following notice.
Yes, my lord.
That is it. This is. And what about this police officer? They are doing what?
They have filed their.
You give an undertaking not to employ
Yes.
anybody below the
Yes,
age.
yes, my lord. Yes, my lord.
Yes, sir.
Take an undertaking from them,
Yes.
not to work anything below the age, not to play any loud music.
Yes, my lord.
These are undertakings, otherwise you take action.
Very much.
And as regards those 75 meters, those people out there, they would not come in because this law came in subsequently. They were given the
That came in
license
subsequently.
earlier.
That's true, Your Lordship. That came in subsequently.
Huh?
That came in subsequently, but after the closure, new things have been emerged. Employment of 18 years, below the age of 18 years, employed of a woman has been made. So let that inquiry go on, Lord. Because let the inquiry go on.
I'm not on that. I'm only touching on page 52, that particular 45. Page 45, na? The
Yes,
improvement of
45,
the-
my lord.
Page 45, na?
Yes, 45, my lord.
Page 42. 16/12/2024.
Only on the violation that this is done without any notice.
Without any notice.
But this will be subject to, however, they won't employ anybody against
Rule 303, Your Lordship.
Rule 30,
Yes,
no,
sir.
against the provision, employing any person against the provisions of the Act and the rules.
That-
Shall not operate loudspeakers.
Will strictly follow the conditions enumerated in the license, my lord.
Ah,
That my lord can add, my lord. In fact, in the license, there are number of conditions, my lord. On violation of those conditions, license can be terminated.
is one of the licenses not to play loudspeaker.
Maybe I'm not sure, my lord, but there are
Then-
certain conditions, my lord.
Conditions are there, Your Lordship.
Loudspeaker
It's
cannot
a-
be there. What about the parking? Parking is also a nuisance.
Yes.
You hear the people out here in Udan Bazaar is facing the same because of a high court. Could the high court be closed because of that? No, tell me. Are these people in the locality out here near the high court are not being tortured because of the advocates' cars being parked everywhere?
Yes, my lord.
Is so. Or even the litigants coming out here, they are being tortured in front of their house, the cars are being parked. Tomorrow you come up and say that the high court should also be closed. And what are else were there? 100
Page 100, NHF,
Parking
several ongoing situations, incidents,
garbage.
garbage.
Garbage is again another thing. The garbage thing, I think that it is for the GMC or the municipal body to look into this. You dispose it of the But I think these findings, these queries also should also be, although they are found not to be tenable, but then also there has to be certain parking in it. They can't be allowed to park in front of the houses.
There are complaints that
You are having it in the residential area, then you have to.
It's not a
take care of
completely recent because my lord, kindly see the parking point, my lord. Point 3. Some of the complainants recorded this in their statements. Though the complaints has no provision of so and so, the IMFL on shop is beside a main road and there are other commercial shops in the vicinity. However, the issue of parking for only one IMFL on retail shop cannot be taken ground to cancel the license. Considering this matter would have blanket effect on other restaurant and shops operating on the side of the same road. It's not a complete residential area, my lord. Residence come commercial area, my lord. There are other shops also.
It's in the main road.
Yes, my lord. It's a main road.
Heard Mr. N.J. Khatania, the learned counsel, appearing on behalf of the petition. Mr. R.R. Gogoi appears on behalf of the Vice Department of the Government of Assam. Mr. G. Bupil appears on behalf of the State of Assam. The petitioner herein is aggrieved by the order dated 16/12/2024 issued by the District Magistrate Nagaon, whereby in exercise of the powers conferred under Section 62 of the Assam Excise Act 2000, hereinafter for short referred to as the Act of 2000, the IMFL on license was closed, whereby the whereby the petitioner's business premises in the name and style of MS Greenland Bar and Restaurant was closed for preservation of public peace with immediate effect and until further orders. The record reveals that the petitioner herein had obtained an IMFL on license bearing number 31/2010-2011, wherein on the basis of which the petitioner was running a business premises in the name and style of MS Greenland Bar and Restaurant. The petitioner admittedly had been paying the license fee from time to time. And as on the date on which the impugned order was passed, the petitioner's license fee was valid. It is the case of the petitioner that on the allegations made by his elder brother and his wife, in a complaint dated 30/6/2023 before the district magistrate. It is the case of the petitioner that the petitioner's elder brother and his wife on account of personal and animosity have filed a complaint pursuant to a FIR lodged by the petitioner against them. These complaints which were submitted to the district magistrate by the petitioner's brother and his wife was inquired into by the additional district magistrate and then submitted a report on 19/8/2023, thereby giving a petitioner a clean sheet. Being unsuccessful in the said pursuit, the brother and the wife of the petitioner took further attempts so that the petitioner's bar cum restaurant could be closed down. This resulted in the closed down, and in that process had filed a civil suit before the court of the civil judge, junior division,
Yes, madam.
junior division, Nagaon, which was registered and numbered as title suit number 26/2024, along with an injunction application being registered and numbered as Ms. J case number 11/2024. However, no injunction was granted. It is the further case of the petitioner that being unsuccessful in that pursuit also, at their instigation, at the instigation of the brother and the sister-in-law of the petitioner, certain FIRs were filed before the Nagaon police station, which was registered and numbered as 1076/2024 and Nagaon Sadar PS case number 1063/2024. The petitioner had further alleged that the respondents, number 8 and 9, have been also personally, have been personally made parties to the instant proceedings on the ground that they had also acted with malicious intent. It is the further allegation of the petitioner that based upon certain reports being submitted by the respondent number 8, the district magistrate Nagaon, by the impugned order dated 16/12/2024, 2024, has closed down the petitioner's business premises, wherein the petitioner's residential premises were attached. And it is under such circumstances, the instant writ petition has been filed challenging the order dated 16/12/2024. The record reveals that the petitioner had also submitted a representation before the Commissioner of Excise challenging the order dated challenging the order dated 16/12/2024. But however, as nothing was done in that regard, the petitioner had been compelled to approach this court. This court duly takes note of that there are various affidavits which have been filed on behalf of the respondents. In the affidavit filed by the respondent number 7, which is of relevance, certain reports have been enclosed. A perusal of the reports enclosed to the said affidavit shows that certain inquiries have been carried out pursuant to various complaints being filed before the excise authorities. In the report submitted by the Assistant Commissioner of Excise Nagaon, along with the Inspector of Excise, dated 29/5/2025, it reveals that there were altogether 6 allegations made against the petitioner. Business premises. However, all these allegations did not amount to contravention of the Assam of the Excise of the Act of 2000, as well as the rules framed therein under. This court further takes note of that subsequent thereto, the Superintendent of Police, Nagaon, had also submitted another report to the Additional District Commissioner, raising allegations that persons below 21 years were employed in the business premises of the petitioner. In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties. The prime contention made, the prime contention of the petitioner herein is that the impugned order cannot survive the scrutiny of law inasmuch as the order which was passed in terms with section 52(1) of the Act of 2000 was without issuance of notice and therefore amounted to contravention of the very provisions of subsection 1 of section 52 of the Act of 2000. Mr. R.R. Gogoi, the learned counsel appearing on behalf of the Excise Department, though submitted that for urgent reasons, powers can be exercised under subsection 2 of section 52, subsection 2 of section 52 of the Act of 2000. But taking into account the tenure of the order, which stipulates that the closure of the business premises of the petitioner beyond the period of 48 hours, it appears that the said order has been passed in terms with subsection 1 of section 2 of the Act of 2000. In that perspective, this court finds it pertinent to take note of subsection 1, section 52 of the Act of 2000, which, being relevant, is reproduced herein under. A perusal of the above quoted provision would clearly show perusal of the above quoted provision, and more particularly subsection 1 of section 52 of the Act of 2000 would clearly show that the power can be exercised by the district magistrate only after issuance of a notice in writing to the licensee. It is seen that the materials on record show that there was no license, no notice being issued to the petitioner prior to the issuance of the impugned order dated 16/12/2024. It is a well-settled principle of law that when the Act stipulates, when the statute stipulates a thing to be done in a particular manner, the same has to be done in that manner or not at all. Keeping that settled principle in mind, in the opinion of this court, if the district magistrate Nagaon was required to pass an order in pursuant to section 52(1) of the Act of 2000, there was a requirement of issuance of notice. Under such circumstances, it is therefore the opinion of this court that the impugned order dated 16/12/2024 is in conflict with subsection 1 of section 52 of the Act of 2000. And therefore requires interference. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The order dated 16/12/2024 passed by the District Magistrate Nagaon, thereby directing closure of the petitioner's business premises, namely in the name and style of MS Greenland Bar cum Restaurant and Restaurant, is set aside and quashed. Number two, the setting aside and quashing of the impugned order dated 16/12/2024, however, shall not preclude the district magistrate to exercise powers under section 52 of the Act of 2000 if in the circumstances the need so arises, but by issuing, by following the mandate of the Act of section 52 of the Act of 2000. Number three. This court further directs, this court further observes that running a carrying on a business of liquor is not a right but a privilege. And under such circumstances, the petitioner herein would be bound to comply with the terms and conditions of the license, as well as the provisions of the Act of 2000 and the rules framed therein under. With the above, there shall be no order as
There's an ongoing inquiry.
I for what?
There's an ongoing inquiry still going on. Then maybe this order may not.
Not said in it.
Very well.
I is for what?
Sorry, man.
I,
Early years.
I, yes,
There's a order for earlier.
Mr. So-and-so submits that he would not press the petition. Finish. See? I could have heard this matter for some more time.
yes, my lord. There was a letter I was written. The letter also. Good city. What did you?
Okay.